Definition of economic loss is harm and financial loss that an individual experiences that is only visible on a balance sheet and does not include actual bodily harm to a person or a piece of property. There are two types of pure economic loss, which are negligent misstatement and negligent act. Negligent misstatement refers to inaccurate statement made honestly but carelessly, usually in the form of advice given by a party with special skill or knowledge to a party that doesn't possess this skill or knowledge. While negligent act refers to act or omission involving the failure to use the degree of care required of a reasonable person in the same situation. In negligent misstatement, there is a landmark case, which is Hedley, Byrne, and Hanli. The court held that duty of care would arise when there are special relationship between plaintiff and defendants. In special relationship, there are three factors, which are: firstly, the plaintiff depends on the defendant's skill and decisions. Secondly, defendant knew that the plaintiff was dependent on him. Thirdly, it is reasonable for the plaintiff to rely on the defendant's skill. In the later case, which is Caparo Industries and Dickman, Lord Oliver had provided guidance in creating a duty of care for negligent misstatement as listed in the slides. In Spartan Steel and Alloys Ltd and Martin & Co., the court held that the damages for physical damage and consequential loss were awarded and held that the loss of profits from the downtime is a pure economic loss that is not recovered. There are four elements that are needed in order to prove negligence, which are duty of care, breach, causation, and damages.
Hi, I'm Rachel Yun, and now we will move on to the next topic, which is recovery of damages on pure economic loss. First of all, we should know what is the policy considerations of pure economic loss. In traditional approach, pure economic loss that non-consequential upon any physical damage is generally not recoverable in tort law, and this is to prevent a flood of claims that are difficult to trace and could place an unreasonable burden on defendants. However, there is an exception from the case of Hedley Burns that introduced recovery for pure economic loss is allowed if it results from reliance on a mispresentation or misstatement by a party with whom the plaintiff has a special relationship. So, what is the current position in Malaysia? Firstly, adoption of Hedley Burns principles. Malaysia courts have adopted the principles laid down in Hedley Burns. In cases like Bethia, Malaysia and Yeoh, Huan, demonstrate the recognition of a duty of care when there is a special relationship and reasonable reliance. Next, application of common law. Cases like Nephin Sendiri Berhad vs. Jonglong Wooten apply the common law of England when local legislation is silent, allowing for exceptions to the general rule of irrecoverability. Not only that, negligent misstatement can also caused by careless conduct. In cases like Development and Commercial Bank Berhad and Liu Wang show that misstatement can also result from careless conduct or service, leading to liability for negligent misstatement and breach of duty of care. Next, limits on liability. In cases like Raja Malaysia and Chow Fung Chu and others, the court held that purely consequential economic loss without injury to a person or damage to a property may not warrant liability. To emphasize the reasonableness of holding an employee liable for economic losses without causing harm to others. In conclusion, the cases discussed highlight that the recoverability of pure economic loss in Malaysia is allowed under the principles of Hedley Byrne, with suggesting that the policy consideration should not limit the scope of duty of care in claiming damages for negligent misstatement.
I'm Hanli. Now we will look into two landmark cases which relate to pure economic loss, which is Hedley, Byrne and Hanli, and Caparo Industry PLC and Dickman. Let's begin with the Hedley Byrne case. In the Hedley, Byrne and Hanli case, an advertising company, Hedley, sought to establish negligence against merchant bankers for pure economic loss due to a negligent misstatement. The House of Law rules in favor of the banker, citing their explicit disclaimer as a key factor negating any duty of care. The court emphasized that a duty of care arises only in cases of a special relationship, especially when it comes to a financial losses without any personal harm. Since there was no special relationship in this case, the court ruled that the defendant was not responsible for negligence. Moreover, the court also outlining three essential factors to establish a special relationship for pure economic loss that can be seen in the next slide. To establish a special relationship for pure economic loss, there are three important factors. First, the plaintiff's belief and reliance on the defendant's information or advice. Second is the defendant's knowledge or awareness of this belief and reliance. And last is the reasonableness of such belief or reliance. Lord Reid highlighted that in cases of negligent misrepresentation, innocent but negligent statements are often not legally actionable. He differentiated between negligent words and acts, recognizing the unique characteristics of negligent words. Now, let's look into the next case, Caparo Industry PLC and Dickman. Caparo test represents the currently applicable test for establishing a duty of care in Malaysia. And this case is the landmark case that introduced the tripartite test or the threefold test for establishing a duty of care. Caparo Industries invested in Fidelity based on the misrepresented financial statements by accountant Dickman, resulting in financial losses, and Caparo sued Dickman for negligence. This case emphasized that an auditor does not own a duty of care to the general public or individual shareholders unless a specific relationship exists. The House of Lords introduced the Caparo test, a three-stage test focusing on foreseeability of damage, proximity of relationship, and the reasonableness of imposing a duty. Lord Oliver in Caparo clarified that a duty of care for negligent misstatement is based on the advisor's awareness of the advice purpose, communication of that purpose, the person receiving the advice relying on it, which then causes a measurable loss. So, it is clear that these two cases, Hanli, Byrne and Caparo Industries, have substantial impact on negligence law, changing how we approach situations involving economic loss and misstatements.
Looking at Malaysia's pure economic loss cases relating to Hedley, Byrne and Caparo. The first case we'll be looking at is CIMB Investment Bank and Ernst & Young. Facts are SJM, a licensed fund manager, faced legal action from CIMB, its clients, for mishandling investments. E&Y conducted statutory audits for SJM, producing audit reports. Securities Commission, prompted by complaints, investigated SJM, leading to the termination of its license. The claimants then initiated legal action against the respondent, primarily alleging negligence. The issues are: did E&Y owe a duty of care to CIMB as investors in SJM? Judgment. High Court applied common law principles from Caparo Industries for pure economic loss claims. Court found foreseeability alone insufficient to establish duty of care, and proximity must be proven. Disclaimers in audit reports and lack of direct relationship led to the dismissal of the claim. Court highlighted the need for careful consideration in determining duty of care in cases of economic loss, such as Hedley, Byrne, and the incremental test from Caparo alone is not sufficient. Court criticized the application of only the threefold test in Caparo, arguing for a more flexible approach. The next case we'll be looking at is Tenaga Nasional Malaysia and Batu Kemas Industries in Durian Bahar. The facts is TMB tasked with relocating electrical lines by the Public Works Department but failed to do so. The collision of the guardrail column cable led to power disruption at the plaintiff factory, and the plaintiff claimed for damages for harm to manufacturing equipment and processes. The issues are determining duty of care and assessing economic loss claims. Principles are distinction made between economic loss resulting from recoverable damage and pure economic loss independent of physical harm, and the Caparo threefold test applied to establish duty of care is foreseeability, proximity, and fairness. Court emphasized duty of care and foreseeability of damage, especially in electricity management, and recognized recoverability of economic loss resulting from physical damage, providing insights into tort law complexities. Lastly, it reinforces the principle that negligence causing physical damage can lead to recoverable economic loss.
The English Court initially took a liberal approach, allowing recovery of pure economic loss claims arising from defective buildings, starting with Dalton and Bruckner Regis Urban District Council. However, this was overturned in Murphy and Brentwood District Council, where the House of Lords held that allowing such claims could open floodgates of litigations. Malaysian courts earlier faithfully applied the Murphy rule to disallow such claims, as in Kerajaan Malaysia and Chia Fong Chiu. However, the High Court in Dr. Abdul Hamid Abdul Rashid and Jurusan Malaysia Consultants affirmed an engineer's liability towards an owner for economic loss arising from faulty construction. This was upheld by the Court of Appeal in Lim Teck Tong and Dr. Abdul Hamid Abdul Rashid, aligning with the Australian position, allowing recovery given sufficient proximity. The judges observed that, given consumer rights implications, it was time for Malaysia to move away from Murphy and its state-balanced interest of justice. Divergently, in Majlis Perbandaran Ampang Jaya and Stephen Fo Cheng Lun, the Federal Court held that imposing liability for pure economic loss on a local authority would not be just, fair, and reasonable, given its responsibilities and limited resources. In conclusion, unlike the oscillating trajectory abroad, Malaysian court system seems to be adopting a balanced case-by-case approach, serving both public policy and consumer protection goals proportionately. Local authorities enjoy near-complete immunity now, whereas professionals like architects and engineers remain susceptible depending on the proximity. Overall, this indigenous jurisprudence upholds both private and public interests equitably.